This lecture series is co-sponsored by IJPM and the Tully Center for Free Speech at Newhouse, directed by Roy Gutterman. That's right, Roy Gutterman. He walks among us, this man right here. This lecture series is also part of a course on law, politics, and media that's team taught by Lisa Dolak, the inimitable Roy Gutterman, and myself. Today, we are fortunate enough to be joined by Peter Canellos, who is editorial page editor of the Boston Globe. The title of his lecture today is Media and the Judicial Confirmation Process. Mr. Canellos is a graduate of University of Pennsylvania and Columbia Law School. He began his career at the Globe, as I just confirmed in conversation with him, a little over 25 years ago, first covering housing, urban affairs, and the overnight police beat. He's covered presidential campaigns. He has served as a national roving correspondent. He's been the Globe's Washington bureau chief. In 2007, he served as the editor of the Globe's 7-part series on Mitt Romney, very well-regarded series. He also served as editor of the Globe's 7-part series on the life of Ted Kennedy. He was editor of Last Lion, The Fall and Rise of Ted Kennedy, which reached number 7 on the New York Times bestseller list. 7-part series, 7th on the bestseller list. I think there's some numerology here in his biography. He was named editor of the editorial page in 2009. Before I welcome Mr. Canellos to the podium, let me just remind you a little bit on the protocol here. Mr. Canellos will speak for about 30 minutes or so, and then we'll have Q&A with the audience. Right around 5 o'clock, we will have a reception in this room. And so if you have the time, I encourage you to stay for some food and continued conversation. Without further ado, please join me in welcoming Peter Canellos.
Pardon me for my notes here. First of all, I want to thank Professor Gutterman particularly for inviting me here. Roy's work is still well remembered at the Globe in some circles. In some circles, it's been a little while, but I really appreciate the chance to come and talk to all of you. It's also great that so many law students care about this particular issue, the nexus between law and journalism, and I happen to believe it is a very sort of symbiotic kind of relationship in the sense that law often impacts what we do journalistically, and the other way around, the media often helps to shape not only the creation of the law, but some of the legal institutions like the ones we're going to be talking about today. So usually when we talk about law and journalism, we talk about the way that law impacts journalism with prior restraints and other legal constraints on the press. This time we'll talk a little bit about how journalism influences the law, and particularly the judicial selection process. Now, back in 1985, 28 years ago, I was in a situation very much like many of the students here in this room, sitting in fact in a room very much like this for my own first day of law school. And like all students who were intrigued by this new experience, we wanted to know about our professor. And at Columbia in those days, we took a 2-week legal method class before beginning the regular first-year curriculum. So our very first professor actually missed a couple of lectures because he was being vetted for a potential federal judgeship. And it may have seemed strange because he was it was very evident to us students, but he was also known as quite a liberal professor. And at the time in 1985, the President of the United States was Ronald Reagan. Ronald Reagan was just in the first year of his second term. And I remember talking to fellow students, and even I think we asked the professor some questions about this, about the judicial selection process. And it was asserted with a lot of confidence around the school that, well, particularly for district judgeships, there's a lot of deference given to the senior senator in the state where the judgeship is open. In that case, it was Daniel Patrick Moynihan in New York. And the Justice Department would sort of strive as much as possible to cooperate with a senior senator. They'd submit several names. The Justice Department would vet them and consider them. And then a major consideration, very major consideration, would be the ABA rankings. And at the time, my professor was, preparing copies of all of his writings and his, entire curriculum vitae to submit to the American Bar Association. And within the American Bar Association, it was considered an extremely desirable job to be on the committee that would vet potential judges because it was so influential at that time. Well, as it turned out, our professor ended up not getting the nomination that he was working for. And I really wish I could find out exactly why that happened. But I can make certain guesses and certain assumptions because the entire confirmation process, nomination and confirmation process, as we know it, was changing at exactly that moment. It's one of those things that, at the time you have no way of knowing, but when you look back, it was actually a very propitious moment. During Ronald Reagan's first term, his Attorney General was William French Smith, who was a very conservative California lawyer with a long-time association with Reagan, but more or less a practicing attorney during his career and sort of respectful of the norms that he inherited in the Justice Department. And for the first Reagan term, they more or less had followed the established protocols, which were sort of what, like what I had described earlier. Ed Meese became the Attorney General in the second term. And Meese had a very different kind of background. He was mainly a political guy. He had been, his title in the first administration had been counselor to the president, but he had been, Reagan's sort of personal political aide going back to when he was governor of California. And he was very, very tied to the national conservative movement. And at that time, the national conservative movement had been gaining significant steam because of the creation in 1982 of the Federalist Society, which, again, looking back, is, I think, a very great moment in sort of the history of law and particularly the judicial nominating process here in this country. And I think to explain for a few minutes the significance of the Federalist Society, you have to even go back before 1982 into what was happening in law schools and around the country in the 60s and 70s, including this campus here at Syracuse University. We all know that it was a time of great ferment, protest, anti-war protests, but it was a rapid period of liberalization within the academy. And a lot of the changes were related to sort of the identity of the students and the identity of the faculty. We went from basically having an all older white male, orderly faculty with a largely white male student body to sudden influx of women students, students of different backgrounds, different racial backgrounds and things like that. And it had a dramatic, almost revolutionary kind of effect on the way that people perceived the different issues that were discussed in the classroom across the university, not just in law schools. And what followed was a period of I think, unease within faculties. The law itself, I think, played a greater role in some of the changes within law schools because this coincided with all the social changes that were going on in the 1960s and early 1970s, that the Earl Warren Court and the Berger Court was busy changing legal precedents in many transformative ways. Civil rights, obviously, was being the first major example, but it went on to issues like miscegenation, the right to contraception, finally the right to abortion, right to, and many changes in criminal procedure as well. But it was a rapid liberalization. I think there were some professors, particularly sort of old school professors, who felt that really settled doctrines within the law had been trampled along this process. So to cite one example, just as a sign of the way that social change occurs, in the 1870s, when the first Civil Rights Act passed by the U.S. Congress went up before the Supreme Court, it was summarily declared unconstitutional. Not summarily, actually, there was one dissenter, Harlan. Justice Harlan dissented in that like he did in Plessy. But unlike in Plessy, there were actually fairly strong doctrinal grounds for the decision in the 1870s, the 1870s, which was that the Constitution doesn't apply to private actions, and a civil rights law that says private accommodations have to accept, all citizens, didn't fit the common understanding of the way that the Constitution was interpreted. Now, after 100 years later, after the civil rights era of the 20th century, in 1964, almost the identical bill was passed by Congress, but this time the Warren Court said that even if it was a backwoods diner in the middle of Mississippi somewhere, that the Commerce Clause could reach that determination of who gets to dine, because an act of discrimination in one place has an effect on broader interstate commerce and the whole kind of culture of the economy and culture of the country, and therefore this law was constitutional. Now, people looking at this could say, well, the country itself was in turmoil over this. There'd been tremendous political change within civil rights. I think that was rightly decided. 99% of the people here would probably say that case was rightly decided right now. I think it's actually a very logical kind of thing to say that even one small act can have an effect on interstate commerce when it's a principle that's that broad and that divisive and that important that's at stake. But a lot of law professors might have felt differently, and there were some people who felt differently during that time, and they felt legitimately that they were seeing doctrines that they felt had been the bedrock of the law that were changing. But the culture of law schools didn't always accommodate them, and having borne witness to a little bit of this, at least a little bit later in the 1980s, there was what I think was a little bit of liberal intolerance that was a kind of understandable clash between some conservatives sort of standing up for what they saw as vital principles that were being eroded by the Warren Court on fairly what they felt were insubstantial arguments. And then within the academy, you have all of these women and people of color and others coming in and wanting to have a place in the institution and wanting to feel a part of it, and feeling some of those senses of unwelcome or discomfort being in a white male-dominated institution and trying to be a pioneer in that way. And what I think resulted by the early 80s was a certain amount of intolerance directed at some of the conservatives. I could cite one example from my own undergraduate years at the University of Pennsylvania. Probably around 1982, which is when the Federalist Society was being started, there was a lawyer who taught an undergraduate legal affairs class, and I had, for our school newspaper, done a story on him at one point. And I was struck by the fact that he was not, this was not one of the great legal minds of the century, but he was sort of an entertaining teacher and a popular teacher and stuff. But he loved the university. I remember seeing him at a basketball game with like 3 of his kids in the little Penn T-shirts and things like that. I mean, it was just, this identification meant so much to him. Well, while I was working on the school newspaper, he, in a class very much like this one, his teaching style, which was very kind of flamboyant, was to try to grill students and really put them on the edge, and to try to rattle them and to try to get at their legal thinking by being really tough. He told a black student, he was challenging a black student to say, well, why should you feel like white people owe you something? It was white people who fought for your freedom. White people fought and died in the Civil War. And the black student was very insulted by that, that question and the way that he did it. And there literally became, campus rallies, people, marching and demanding the firing of this guy. He was only an adjunct, so of course the faculty didn't defend him hardly at all. And I can't even remember exactly how we editorialized about this on the school paper. I suppose we probably did say he should have been fired because there were larger principles at work in terms of the sense of welcome that was felt by students there. But his entire career, his entire reputation and everything was blown out. Now, I think that what frightened a lot of conservatives on campus during that era was exactly that kind of thing. It wasn't the give and take of intellectual debate. It wasn't, 2 faculty members saying, does the Commerce Clause really strike a, diner in Mississippi or not? Wasn't that. It was the sense that if you didn't adhere to a certain, in their mind, kind of protocol, in terms of your speech and your actions on campus, your career not only could be over, but your personal honor, your reputation would be sullied. You'd be accused of being insensitive in a very grand way, in a way that struck people deeply to the core. So I think that some of that anger, some of that reaction went into the creating of the Federalist Society, which had a very bold kind of mission. I think the opening manifesto declared, law schools in the legal profession are currently dominated by a form of liberal orthodoxy which advocates a centralized and uniform society. And it started with chapters at 3 law schools, and today it has 200 chapters, 10,000 law student members, and 30,000 practicing attorneys. Within the Federalist Society, it became a kind of cabal almost, but a source of advocacy and a place of refuge for a lot of conservatives in the legal academy. Now, Ronald Reagan obviously was the most conservative president, really, of the modern era, certainly up till that point when he took office. Ed Meese was very well schooled in the Federalist Society. He had spoken to the Federalist Society many times. He was an advocate for originalism, which was even then just an emerging ideology, but it was sort of the blanket conservative response to what they saw as the excesses of the Warren Court and the Burger Court. And that year that I was a first-year law student in 1985, Meese began asserting what he felt was the Reagan administration's prerogative to try to remake the judiciary with more judges who believed strongly in originalism. 1986 turned out to be a very key and interesting year. In Indiana, the Reagan administration nominated Daniel Mannion, who was the son of a founder of the John Birch Society, and who, even though he had been an assistant state attorney general briefly, it was widely believed that he had gotten that sort of through his political contacts and was actually, the scuttlebutt certainly was a really subpar lawyer. Most of his experience had been in personal injury law, and he was nominated for a circuit appeals court judgeship, which those aren't the usual credentials. You know, circuit appeals courts are doing much broader appeals work and talking about constitutional issues, not personal injury issues. And the ABA even noted that one of the briefs that he submitted in his vetting process was full of typos and misspellings and things like that. And so immediately there was this sort of act of, revulsion that, that here was Ronald Reagan kind of breaching the tradition of appointing really high qualified people to the circuit court bench. And Mannion and his supporters, including Dan Quayle, who later went on to be vice president, really fought back on this, and they took the argument, as Mannion himself testified in his confirmation hearing, that the ABA had a liberal bias. The ABA also had a bias in favor of lawyers from big firms and from the sort of ritzy elite of the bar against people like him, who was just a, wise country lawyer in Indiana. And he then took it to another level when he said that the ABA's litigation department at that time, litigation section, had done some joint kind of brainstorming and networking with their Soviet counterparts. And that was, throwing a sort of accelerator into this thing. And Mannion ended up being confirmed. Also in 1986, confirmed but by a close vote. Also in 1986, Antonin Scalia was nominated to the Supreme Court. He was a young man at the time on the DC circuit, very conservative, very much an advocate of originalism, in every sense the conservative theorist that he is today. But the confirmation hearings went swimmingly well. He brought his 9 children in, and he had many other relatives, and he had Italian-American groups celebrating the fact that he was the first Italian-American nominated to the court. And, he came off like a loving, warm-hearted patriarch, and he was unanimously confirmed. Can you imagine something like that happening today? Unanimously confirmed by the Senate. So in 1987, the lesson that seemed to have been visited on the Reagan administration was, if somebody's credentials are good enough and they are, seen as a quality candidate, there should be no challenge to their fitness to serve on the bench. In other words, Mannion may have been a little questionable there because his credentials weren't all that great and he riled things up. But Scalia, who had gold-plated credentials, was totally unchallenged. So they decided, the Reagan administration decided, to nominate Robert Bork in 1987. Now, more than Scalia, Bork had been sort of the granddaddy of all conservatives and advocates for originalism. He was a creature sort of the academy. He had the sort of flowing beard and the curly hair. You saw the videos earlier, so I can skip some of this stuff. But, his manner was very imperious and intimidating. But his credentials were indeed perceived at the time to be unimpeachable. I mean, he had been a former Solicitor General, even though there was a little controversy about the the Saturday Night Massacre during the Nixon administration, where he had acted to fire the special prosecutor. But even then, he had done it because he made a convincing argument that he did it to preserve the Justice Department's integrity rather than having all the senior officials resign and leave the department in disarray. And that was really not a big issue. But what was an issue was the fact that he had been, for pretty much 2 decades, criticizing all of the decisions of the Warren Court. And Senator Kennedy, who I've written about and studied, felt a personal association with a lot of those decisions. I never was quite convinced that John F. Kennedy was the great liberal that some people remember him as, and in fact it was Ted Kennedy who sort of spun JFK's reputation as a great liberal, because Ted Kennedy, had been given his inaugural speech in defense of the Civil Rights Act of '64 and declared that it was the dying act of his brother, and his dying wish of his brother was to see this bill go through, which I don't think there's that much evidence that it really was the dying wish of his brother. But it was very important to Ted Kennedy, and Ted Kennedy saw his entire, his and his brother's, his late brother's legacy imperiled to some degree and criticized by Bork. So Kennedy came out with a speech that, I don't know, did you have Kennedy's speech in the earlier thing? Somewhere I wrote down Kennedy's speech. He said, this is one of his most famous utterances. He came right out of the chute and said, on the very day that Bork was nominated, and again, in the past, there had always been deference to the candidates. You never criticized them until after the confirmation hearing or the questioning during the confirmation hearing. But Kennedy came out on the very first day and said, Robert Bork's America is a land in which women would be forced into back alley abortions, blacks would sit at segregated lunch counters, rogue police could break down citizens' doors in midnight raids, school children could not be taught about evolution, writers and artists could be censured at the whim of the government, and the doors of the federal court would be shut on the fingers of the millions of citizens for whom the judiciary is often the only protector of individual rights that are at the heart of our democracy. It was quite a mouthful. What Kennedy had essentially done was change the rules in a dramatic way, introducing the idea for the first time, really, that the substance of a judge's opinions and a candidate's opinions could be a reason to reject them. In the past, there has been some very contentious Supreme Court nomination fights, but they tended to be over people's political activity or their personal character, their past, associations, things like that. It was not their actual legal views. And I think that some of the conservatives had rightly assumed that Bork deserved or was going to get a free pass on all of these views as long as his credentials were viewed as being sacrosanct. So they were caught flat-footed by this. And Joe Biden, who was then the head of the Judiciary Committee, delayed the hearings until September of that year, giving Kennedy the whole summer to rally liberal support against Bork. And they ran it essentially like a political campaign. They ran advertising, they had rallies, they got civil rights groups out, there were campus protests, even at the campus that I was at, that were all dedicated against Bork in a very strong way. And in the end, Bork was defeated 58-42 in what kind of became a referendum on the constitutional changes of the 60s and 70s. And a lot of people believe that was a great moment in Kennedy's career. And to some extent, I think it was. I mean, it was a great political act, and people really haven't stepped forward in quite the same way to challenge the legitimacy of those decisions since the Bork nomination. But it did have unintended consequences. And what we saw soon afterwards was, of course, as people might have predicted at the time, and some people did predict at the time, once the shoe was on the other foot, there was an opportunity for payback. During the Clinton years, President Clinton nominated particularly a lot of district judges who were practicing defense attorneys. And Republicans in Congress, once they took over Congress in 1994, pretty much refused to either hold votes or filibustered against every one of them. And the grounds were they would take with each of these judges defense cases that they had represented people on and use the facts of the case as a sense of advocacy. So it would be, you know, so-and-so, who's President Clinton's nominee for district judgeship, represented a man who raped and murdered his wife and who supported, you know, who opposed the death penalty on the grounds that, you know, it would be too cruel to put this person behind bars. There were those kinds of attacks. Many of those district nominees were people of color. And in 1995, about 20 of them, Clinton abandoned the fight and sort of, you know, withdrew the nominations to avoid a big showdown with Republicans in Congress. And at the time, it was considered a betrayal of liberal principles by Bill Clinton and, you know, sort of self-interested kind of move by Clinton. And there was a lot of bad feelings surrounding it. But sure enough, when George W. Bush became president, and once again, you know, political equation had changed, President Bush made a lot of very conservative nominations. And sure enough, Democrats in Congress began filibustering them when they didn't have enough votes to defeat them. Then when they finally took over Congress, they refused to confirm almost any of them. Now, I actually know one or two people who had been Bush-appointed judges at that time. And one of them was a conservative friend of mine from college who indeed was, you know, a principled conservative, but it was for the Court of Federal Claims, which is where people who have claims against the federal government get their cases adjudicated. And somebody who's kind of a property rights conservative is actually, you know, the pro-defendant position for the Court of Federal Claims. And, you know, it was hard to see why Democrats would be so exercised about this appointment. And I could see, as this friend of mine went through this process, how embittering the whole thing was. And it almost like brought back some of those issues we were talking about in the law school broader campus in like the 70s and 80s, where people begin to feel that their personal honor is impugned. And those of us who are journalists, those of us who are politicians, or people who are kind of in the fray and accustomed to the give and take of politics, can sometimes take it and give it, and, you know, you're accustomed to being accused of things and giving back. But I think that when some of these very private people who are nominated for judgeships see their words twisted or the decisions thrown back at them and things like that, it injures them in a very fundamental way. They feel shocked, horrified, maligned in a way that I think almost changes their personality and their character. I also think that when people confront this confirmation process, even if you go into it not having any strong sense of loyalty to the Federalist Society or to the liberal American Constitution Society or anything like that, within a few minutes you find out that one side or the other is attacking you relentlessly and, in your mind, completely unfairly. The other side is defending you. So you're almost thrown into the arms of the extremist groups. And I think people do develop loyalties that then carry over onto the bench that make them more ideological in that way. So I think we're stuck right now in terms of federal judgeships with what's kind of the worst of both worlds. We have a confirmation process that serves to push even the more, you know, innocent centrist nominees a little bit towards the extremes. It creates judges who, once they get on the bench, can be quite embittered from the confirmation process. And I think that, you know, it's undermined public confidence in the whole idea of an independent and politically insulated judiciary, which clearly was part of the framers' conception in giving life tenure for judges and in suggesting a kind of hybrid confirmation process. So what's the solution? The solution, I think, is in some ways to try to rebuild support for that original conception of how a judgeship, you know, what the proper protocol is for a judgeship that was outlined to me back in 1985. And I think there was a kind of balance and a kind of symmetry and a kind of common sense to it, where the senior senator in a state got a certain amount of deference in terms of choosing particularly district judges. The administration would vet those candidates and could bring some of their own concerns to the table, but it was not considered appropriate to be rejecting all of the candidates and replacing them with a politically correct choice. The American Bar Association was considered a prime source of wisdom in terms of determining who was fit, who was qualified to be a judge. And the confirmation process was more orderly, more respectful, more deferential to the nominees, at least until they finally came time to vote. How do we get there from here? I think there has to be a greater political demand for a return to some of the neutral kind of centrist institutions and traditions and practices that got cast aside maybe 20 years ago. So there have to be people seeing a good in creating a system like that and pushing for it. I think that people on the extremes have to see how that kind of a system could work for them over the long term in a way that leads them not to absolutely paint everything in terms of a desperate need to defeat the judges who are on the other side, are perceived to be on the other side. Now, we can't really have this conversation without talking about abortion. There is obviously something uniquely divisive about abortion. And so I was sort of thinking as I was coming over here, what would I tell somebody who passionately felt a pro-choice or pro-life argument that it was a core proposition, maybe a core moral proposition for the pro-life person, and a sense that a woman's dignity is utterly at stake on a pro-choice position. What could you say to them? And I think what you could say to them is that, in a more neutral system, you're far more likely to have judges that are going to, reach a wise accommodation on these facts. And by maintaining your sort of absolutist position, you're regularly courting the danger that the other side will take over. And so almost as a political science balancing act, it's like, let's have a compromise. Let's just try to see where the law leads here, rather than be on this constantly shifting boat where the fate of Roe v. Wade is at stake in every nomination to the Supreme Court, and where people who are even being nominated for the Court of Federal Claims are being vetted on the abortion issue just because somewhere, 20 years down the line, they may get promoted to, the district court and then the Circuit Court of Appeals and then the Supreme Court. And people don't even want to see the pipeline developing of justices on that side. And I think that, clearly a huge percentage of the bar is not even subject to consideration for judgeships now because they've taken views on abortion and that, they aren't even considered potential candidates for judgeships. Many of the people who are politicians who I think played a useful role on Supreme Courts in the past and on courts of appeal in the past, now it's almost impossible for a politician to get confirmed, so they're not even considered. So there are lots of reasons why we should be very, very concerned about the state of judicial confirmations today and should be looking for ways to try to rebuild the system that we had 30 years ago. So happy to take questions now. I know Professor Gutterman was telling me that you have an actual judge coming next week, so he might have a very different view of this, and depending on how his confirmation hearings went, I'm sure. Yes.
Given your account of this history and of the pivotal role that Senator Kennedy played, looking back, do you think you should have done something differently? I mean, he made a big deal out of this. You say he politicized it from the very beginning, changed the rules. I mean, what would you, knowing the consequences of the tit for tat that emerged and the kind of judiciary and confirmation process we're left with?
Well, I think it's one of the great chicken and egg questions in politics of how this happened. And I think the question that people have is, did Ed Meese change the rules by making more politicized appointments and Kennedy almost had no choice but to respond in a political manner? Or, did Kennedy kind of jump the gun at a time when Meese was making more political appointments but hadn't, utterly submitted to a political a partisan, polarized process. So I think that, probably you can say that both sides bear some kind of blame, but it's also just one of those, phenomenons that pops up in American politics. And, we have these neutral institutions that people abide by and follow until somebody openly challenges it and knocks it down. And it's very hard to kind of recover that sort of consensus trust after somebody knocks things down. And, the conservative movement that I described coming out of the 60s, the reactionary conservative movement that the Federalist Society represents and other things, it has tried to undermine these neutral institutions, and have certainly done it with the science institutions too. And there are, they created conservative equivalents to many of these scientific organizations with names that sound just like the proper, the original organization. So something that calls itself, whatever, the National Psychiatric Board or something will come out and say, homosexuals are 100 times as likely to rape children, and women who work outside the home are, their children have 5 times the rate of mental illness. And it's advancing a political view, but it's a largely bogus organization. But once you've made the political critique that says, the American Medical Association has a liberal bias, and why should we even pay attention to them? It's very hard to rebuild trust in the American Medical Association, at least among conservatives.
Can you compare and contrast the Bork hearings with the Clarence Thomas hearings? And why do you think the Democrats were able to stop Bork but not Clarence Thomas?
I think that, the short answer in the Bork case is that their heart and soul crucial interest, the way that Kennedy presented it, was the whole legacy of the 60s and 70s and all the social change that had happened during that time was, became the focus of the Bork hearings, and they were able to sort of present things that way. And when it came to, choosing which side you're on, that carried the day. With Clarence Thomas, the unfortunate issue was there were a number of senators like Nancy Landon Kassebaum, and there were other people who just felt like the allegations against him weren't proved. Now, subsequent research and subsequent books and things, including the Jill Abramson and Jane Mayer book, have made a very strong case that Anita Hill was telling the truth. And I think that many people watching it felt instinctively that she was telling the truth. But I think a lot of senators were uncomfortable in that he said, she said sexual harassment situation. A lot of the male senators, by the way, didn't want to sort of prejudge that situation. That, okay, she says that he was making these lewd comments and was trying to date her. He says it's not true. How do we begin to process this? And it was just a very, very different kind of hearing. And I don't think that the impetus for the attack on Clarence Thomas was a sense of ideological distaste for a conservative. I think that the Democrats initially with Clarence Thomas were willing to give him a pass and allow him to go in the court because they didn't want to be seen attacking a black conservative in that way. But the Anita Hill thing surprised them as much as anybody else. It just sort of popped in there. So it's kind of anomalous to the trajectory of contentious confirmation hearings that we're talking about. Even under the old rules, if somebody came forward and said that there was he was the head of the EEOC or whatever at the time, or the Civil Rights Commission, one of the two, or something, that a senior government official had been sexually harassing somebody, it would have been an issue even by the early 1980s and 1970s standards. Yes.
Of course, I was disappointed to hear that I will not be able to be a judge anymore, given that I have a position in abortion.
I know.
But no, what I wanted to mention was that you mentioned how do we solve this problem, right? And you suggested that we have to get back to.
No, are you a judge? Are you a judge?
No,
you
don't.
don't.
I'm not even a legal anything. I'm a visitor. But anyway, so what I wanted to mention is that about a year ago, I remember reading an article in The Economist that it talked about the fact that the polarization of the parties here has to do with the fact that they don't interact, that they basically spend their whole time, campaigning, right? And then they just don't have a forum where they socialize and they get to know each other and they become friends, basically, right? So it's just, so what I'm saying is that it may be even beyond of what you're suggesting to change the way they work.
Yes.
To make it such that even if the confirmation process were as it is right now, at least there's not the polarization that we see.
No, I think that's an excellent point. I mean, if there were more comedy, between Democrats and Republicans on other issues, it would be easier to see them coming to a kind of common ground agreement on judicial nominations. They did try to. Remember the Gang of 14 during the Bush era? There was a challenge to the filibuster rule that Democrats were using to try to defeat judges or prevent votes on judges. And this argument came up that because the up or down vote on a judgeship was mentioned in the Constitution, that the Senate filibuster rule should not apply to judgeships, and they called that the nuclear option. And then when they realized that was bad terminology, they called it the constitutional option. But a group of 14 senators, 7 from each party, I think it was 14, maybe it was 12 or something like that. But anyway, a group of senators got together and forged a kind of compromise that prevented that. And the compromise had said that only in extreme cases would they use the filibuster on judgeships. But I also think the argument that you're referring to from the Economist is that, 50 years ago, before air travel, members of Congress would essentially all live in Washington. A lot of them would have their families back in their own home states, but they wouldn't be going back and forth on weekends. So all weekend they'd be playing poker together, they'd be, hanging out, they'd become friends, and, that a lot of, business, a lot of compromise was achieved over, glass of wine and a little bit of, or something a little harder than wine, and playing poker and whatever, and that doesn't happen at all anymore. And those are all excellent points. Yeah.
It would assume to me, just a lay standpoint, that the Judicial Department or the President would do dynamite, intensive background checking before they throw a name up there.
They do.
But
they do to the point where they can't.
Something always creeps up to the top of the bottle.
I think it's sort of not. It's not entirely predictable what the thing will be, and they do such vetting that they're slow with these nominations. And I know other people who've for years have been in the vetting process. It's a very, very laborious test of all your finances and all these kinds of things. But we were talking about Caitlin Halligan, who had been the assistant to Eliot Spitzer and the chief litigator for Eliot Spitzer when he was Attorney General. And she had brought a case at Spitzer's bequest that would hold gun manufacturers liable for actions that people used with their guns. And you can see what Spitzer was thinking, that after the tobacco litigation, this was a way to say, hey, if you make a dangerous product and you put it in the hands of a crazy person and something bad happens, you should have known that that was happening, and so you, the manufacturer, has to take some responsibility for who you're selling to. But it's an extreme position, and the fact that she was associated with it has, she was completely blocked by the NRA. Maybe the Obama administration should have foreseen that and not appointed her. But on the other hand, how fair is that? I mean, they were probably checking every word that she ever said to see if she ever said anything about abortion, and they didn't even pay attention to this gun case that she'd been involved in. So it's a tough one.
Maybe not realizing the strength of the NRA coming about, giving her due.
Yeah, I think the fact that the nomination also happened during a time when there's so much attention being given to gun violence, and the NRA is already so politicized.
That would have been a Spitzer political move, too.
Yeah. Yeah.
But I still don't understand, with the amount of force that the federal government has, the amount of investigative powers that they have, that they don't find all these things out and say, this thing is going to crop up.
Well, I mean, you may be referring to the Clarence Thomas hearing, and you may be right about that. There could have been more vetting on Clarence Thomas. But I think the problem is not that these people aren't vetted enough, or that they're flawed nominees, or that these things that are coming out about them are truly so shocking. I don't think it's that. I think it's very ideological. It's they don't want people that they perceive to be too associated with the right to privacy and abortion, but also some other issues. We've seen gun control and some of these criminal issues too.
It's all political. It's dead on all political.
Yeah.
I don't know if it's money driven, but it's...
No, it's all political, but it's not that the nominees themselves have terrible foibles in their past. I think it's that, they're normal human beings who had to take some political stances, or, you know, I mean, what was Caitlin Halligan supposed to do? She was the Solicitor General. Spitzer was the Attorney General. He said to bring this case. She brought it. That's kind of what lawyers do, you know. And maybe she believed in it and she advanced it, but you know, she's bringing a case. She's not supposed to be out there questioning her own, you know, advocacy.
She couldn't say no to that, to Elliot Spitzer.
Who can? I was wondering if you could talk about, you mentioned this a little bit in your remarks, how do you think the behavior of sitting judges is fed into this cycle that you identified? So there's some...
Well, we were talking a little about this over lunch, that I do think that, you know, the politicization has become so strong that even sitting judges are participating in it in a way that's kind of shocking and objectionable, particularly the Supreme Court justices who regularly headline these events for the Federalist Society and the American Constitution Society. I mean, just over the last year, they had Alito and Scalia. I mean, Alito and Scalia and Thomas essentially speak at every National Federalist Society convention. Ruth Bader Ginsburg was the keynoter for this year's American Constitution Society convention, and she also has a lectureship or something given her name by the now Legal Defense Fund, which is a very strong advocate for abortion rights. And I just think it's really unwise for these Supreme Court justices, and very unseemly for Supreme Court justices to be headlining these extremely partisan events. You know, it's hard to imagine that once they get on the court, they're able to maintain a sense of objectivity when they're so clearly basking in the, you know, glory of you know, leading these armies that have absolutely set positions on these constitutional issues.
Do you think they're being paid to speak as a matter of?
No, I think that they've been relatively careful about money, but there are a few. I mean, their spouses forget about it. I mean, there's a lot of money being made by family members of various justices that aren't scrutinized by the Supreme Court. The Supreme Court sets its own ethical rules, and there are a few like borderline money things, but generally it's not been money; it's been ideology that's been driving it.
The recent demise of and I can't remember, it was the Boston Times, the alternative newspaper.
Phoenix?
Oh yeah.
Oh, the Phoenix? Yeah. Boston Phoenix.
Yeah, Boston Phoenix, but I don't think
Is that likely to have any effect on the Boston Globe, either positively or negatively? In other words, there's been some kind of competition or kind of pushing the Boston Globe sometimes to be more investigative?
Yeah, I think that the Boston Phoenix, and we actually said in our editorial that the Phoenix, when it was first created, was part of an alternative journalism movement that challenged assumptions in a way that the mainstream media didn't, and that it's a moment to reflect on the stories that won't be told in the Boston Phoenix and stuff. Now, I do think the Globe can pick up some of that slack. But I also think that the alternative journalism movement kind of petered out in the 90s and ceased to be as powerful a news-generating force as it was in the 70s, which is probably the heyday for like the Village Voice and the Boston Phoenix.
To what extent do you think the problems in these confirmation processes are related to the fact that they involve lifetime appointments? And obviously, if you were to move away from that, it would require a constitutional amendment. But if this is really causing the gridlock, maybe that's and then maybe there are other reasons for a constitutional amendment on that too, aside from that.
I think that's possible. I mean, it's possible that could make a difference. I mean, certainly we've seen the presidents picking younger and younger justices, and even judges for lower courtships, because they want to leave their stamp longer. So if you take somebody who's 38 years old and put them on the Circuit Court of Appeals, and if they're an ideological firebrand, it's easy to envision them being there 50 years later, or possibly being there 50 years later, but certainly being there 40 years later. And I think that is on the minds of the president of the Justice Department, that they're taking advantage of the lifetime tenure in that way. And certainly because people have been living longer and have been easier, we've seen the standards for when it's appropriate for a judge to retire change. I mean, Ruth Bader Ginsburg is, 80 years old and has had cancer and all those kinds of things, and yet she might retire at a time when Obama can pick a successor, but it doesn't seem like it's in her mind to want to retire, nor is it certainly in Scalia's mind or anyone else. So, you know, I wouldn't come right out and advocate for a constitutional amendment to change judicial terms, but it definitely is a factor that adds to some of the machinations that were going on.
I wondered if the way we're changing in society regarding our moral values could alleviate some of the polarization. The reason being is you can see with the case in the Supreme Court right now, where even Republicans send this amicus brief in favor of Proposition 8. I mean, the opposite.
Some Republicans
Right,
did, yeah. Some Republicans did. Yeah, I think that if the issues themselves became depoliticized, that would make a difference.
Right.
I also think that what Justice Roberts did in the Affordable Care Act was an act of leadership and an act of conscience that that reflected his concern as Chief Justice for the reputation of the Supreme Court. That if they you know, voided Obama's signature accomplishment on a vote that was, you know, 5 Republican appointees against 4 Democratic appointees, that it would deeply damage the Supreme Court. I think he was right that it would have deeply damaged the Supreme Court, but I think it was a real act of courage and leadership and willingness to stand apart. And for all that Roberts has spoken before the Federalist Society in the past, I think, you know, he's been quite careful as Chief Justice not to appear to be very partisan, and you know, his behavior is very much in contrast to Alito, Thomas, and Scalia's. And so I have respect for Justice Roberts, Chief Justice Roberts, and you know, he might be somebody who can help bridge some of the gaps. You know.
We have time for probably a couple more questions.
I think from the students, some of you were at the lunch, I know. Yeah.
Once they're on the court, how much do you think judges are swayed by public opinion? Like, I changed my Facebook profile picture. I didn't pretend that it had any effect. But the people who are actually protesting out in front of the hearing, do you think they have any effect?
Well, it's an interesting question about sort of where the relationship between the law and changes in society and social changes. And I think that, you know, even conservatives who are promoting a certain amount of originalism, you know, it doesn't behoove them to keep their head in the sand completely about social changes. And the fact that the gay marriage decision the gay marriage issue has gained support so strongly, it does make you kind of feel like the justices might find a way to strike down DOMA, or if they don't, and if they uphold it, that, you know, in fairly short order there'll be another argument and they'll be willing to reconsider some of these things. And you know, how much of that is that society's values have changed? I think that, you know, an honest assessment is, yes, they have changed, and that should change the legal calculus to some degree too. And I don't think, you know, when the Warren Court upheld the Civil Rights Act of '64, I don't think that was a craven caving in to, you know, protests and popular demands. I think it was a recognition that this issue had become so prominent and so divisive in such a way that it really did rise to the level of affecting interstate commerce. And I think it was a wise reading of the Commerce Clause, you know, but it wouldn't have happened if views hadn't changed and society hadn't evolved. Yeah.
What do you think the media and journalism has played into the politicization of, like, the justices? And I know now a lot of times people know exactly, you know, what party nominated who, where they fall on certain issues. And I think that's due in large part to what we see on TV and what we read in the paper.
Yeah, in fact, I sort of spent too much time talking about the 60s and 70s and didn't get to some of the points I wanted to make that actually did tie it to the journalism question too, a little more strongly. Which is to say that journalism played, I think, a very proud role in the liberation movements of the 60s and 70s, not in an advocacy way necessarily, like the alternative journalism might have been more of an advocacy role, but, you know, in everything from pictures of Bull Connor, you know, hosing down peaceful civil rights protesters, to the Watergate coverage, to many of the the exposure of of wrongdoing and money in politics and things like that, you know, greatly changed people's attitudes. But I think that reporters are so heavily into the orientation of kind of peeling back the facade and revealing the sort of corrupt underbelly to some degree. that some of the other values, like that we were talking about in the confirmation process, and the need to have people who had, some degree of independent credentials, but also who would feel as though their mandate as judges was to assess the law purely on the merits. That by trying to expose the the biases of the court, you're also kind of destroying the social pressure on judges to stand apart from that. And I think that there's also a difference. I'm now the editorial page editor, in the perspective of somebody who's a reporter and who really just wants to sort of uncover what's going on. And a lot of these confirmation hearings were portrayed as, a fight over abortion rights and a fight over the, legacy of the 60s and things like that. When you're sitting in a different chair and your sort of mandate is to think about what's best for society, you don't necessarily view the issues the same way as when you're a reporter kind of trying to pick your way through the facade and kind of find the underlying truth in things.
We are now out of time. Please join me.